Hi, Praj. Hi, Praj. Test 1, 2. Yeah.
Test 1, 2. All right, here we are. Hello. Can everybody hear me in the back? A very warm welcome to our Grand Mooters, former and future Grand Mooters. All the students, faculty are here, staff, and it's great to be able to welcome everybody to the Grand Moot again, the 2022 edition. I want to start by acknowledging this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful for the opportunity to work and learn on this land. Tonight's moot problem concerns the constitutionality of a law that regulates social media platforms for the purposes of promoting free exchange of ideas. As you will hear, it explores competing conceptions of free expression and their implications for equality rights. We'll hear arguments on these issues from the four Grand Mooters. Benjamin MacLean-Max and Laura Goldfarb will present the social media platforms arguments, and Ivy Shu and Adrianna Mills will put forth the government's response. They will be making their submissions to a distinguished judicial panel. Our Chief Justice, Julie Thorburn from the Court of Appeal of Ontario, Justice Lorne Sossin, also of the Court of Appeal for Ontario, and Rita J. Maxwell from the Ontario Superior Court. I want to say that we're really grateful for Justice Sossin, who stepped in at the 11th hour when we learned that Justice Kassira unexpectedly was unable to join us. But I want to say that the 11th hour notwithstanding, I don't think anybody should expect him not to have read the factums or cut anybody any slack and be anything less than extremely well prepared. So this will be a very fun session we have coming up. Also, as always, we are so grateful for the generous support of the Grand Moot sponsors, McCarthy Tetro. They've brought us years of Grand Moots, and so tonight we're in for another mooting feast. The two people who may well have worked harder than anyone are our two student chief justices, Mackenzie Faulkner and Charles Ma. So Mac and Charles will now come up and introduce the moot problem. Over to them.
Good evening, everybody, and thank you for coming out to this year's Grand Moot. As Dean Brunet mentioned, my name is Mackenzie Faulkner, and this is Charles Ma, and we've had the privilege of serving as this year's Chief Justices of the Moot. And we're very happy to see a full house for the first time since before Charles and I even stepped foot in the law school for the Grand Moot. We would like to echo Dean Brunet's comments and give a special thanks to our generous sponsor, McCarthy Tetro, whose support every year makes the Grand Moot possible. And in particular, we'd like to thank Holly Kallmeyer, Chris Puskas, and Liliana Stonich, who are invaluable to the organization and planning of tonight's event. We'd also like to thank the many members of the law school community who played a crucial role in helping draft this year's problem and helping the Mooters prepare. And that includes the Grand Moot bench clerks who provided invaluable research to help us prepare what we hope will turn out to be an interesting problem. And it also includes Dean Brunet, Assistant Dean Faraday, and the many other faculty members who generously donated their time to looking over the problem or doing practice run-throughs. Thank you all for your help and continued support. At this time, we ask that members of the audience turn their phones to silent. And we also ask that you please not leave the moot once it's begun so as to not distract the mooters or the panel. And so now Charles will introduce a summary of the problem.
Thanks, Mac. So we know everybody is looking forward to the moot. We'll just provide a very brief summary of the problem that the mooters will be arguing today before turning it over to them and the distinguished panel. The appeal that you'll hear tonight takes place in Flavel, a country that is functionally equivalent to Canada in both law and history. The mooters will explore the relationship between privately held social media platforms and the state by arguing the constitutionality of a new law named the Digital Public Squares Act, or the DPSA for short. The DPSA prohibits social media platforms from censoring content based on viewpoint, with some narrow exceptions. That means that platforms may not delete, alter, or do anything to lower the visibility of content based on the viewpoint expressed therein. However, platforms are permitted to lawfully display a notice beneath any content that they may deem problematic, which states that such content might have previously been deleted or censored, but for their obligations under the DPSA. ChitChat is a social media platform operating in Flavel. It operates very similarly to many social media platforms that you may be familiar with. After the DPSA was enacted, ChitChat decided not to post such a notice beneath the content it wished to remove. Rather, it continued to delete posts deemed to be particularly egregious. Within one day, ChitChat was charged with more than 1,000 violations of the DPSA. In response to these charges, ChitChat challenges the constitutionality of the DPSA. First, ChitChat argues that the DPSA infringes the freedom of expression under Section 2B of the Charter by compelling ChitChat to host expression which it does not wish to host, and by prohibiting its content moderation practices. Second, it argues that the DPSA infringes the right to equality under Section 15 of the Charter because the increase in offensive and derogatory expression on the platform since the DPSA's enactment disproportionately affects racial and religious minority groups, as well as the LGBTQ+ community. ChitChat argues that neither infringement can be justified under Section 1 of the Charter. And today, the Supreme Court of Flavel will hear the parties' submissions. We are very fortunate to be joined tonight by the Honourable Justice Julie Thorburn of the Court of Appeal for Ontario, the Honourable Justice Lorne Sossin of the Court of Appeal for Ontario, and the Honourable Justice Rita Jean Maxwell of the Ontario Superior Court of Justice. We will now cede the floor to the Grand Mooters, Benjamin MacLean-Max, Laura Goldfarb, I.B. Zhu, and Adrianna Mills.
Presiding.
Welcome to the Flavelian courtroom. We are delighted to be here with you today. Unfortunately, one of our colleagues was not able to be here today, so we have the honor of having Mr. Justice Sossin join us in his stead. So,
well, I can't fill Justice Kassir's shoes, but I'm more than happy to step into them tonight, and pleasure to be included in this Grand Moot.
And we're all delighted to be here. Counsel, are we ready to begin? All right. This is the matter of R versus ChitChat. Whenever you're ready.
Good evening, Justices. My name is Benjamin MacLean-Max. My co-counsel is Laura Goldfarb, and we come before you today on behalf of the appellant, ChitChat. Justices, everyone deserves equal access to public spaces on the internet. As one of the largest social media companies in Flavel, ChitChat has a tailored moderation policy whose goal is, and always has been, to foster a safe and inclusive digital forum for equal, civil, and open discourse among Flavelians. Balancing equality against free expression online is difficult, but the DPSA is a blunt instrument aimed at a subtle and complex problem.
But Mr. MacLean-Max, what is the real problem here? I mean, we've got about, 1,432 posts that were found to be harmful or abusive on a given day. By my recollection, that's about 0.15%. What's the problem?
Justice, these posts are on a daily basis, cumulative in their effect, and frankly, the question of our Section 2B rights are engaged whether or not we're dealing with tens of thousands, hundreds of thousands, or millions of posts. We as a social media company deal with tens of millions of posts on a daily basis, and our right to express ourselves through moderation and the right of our users to be free from discriminatory effects is not intrinsically dependent on the absolute number of these posts.
But we've got a line here. The law has set out a line. It can't be lawful. It can't be exploiting people on the basis of sex and a bunch of other things. And that's a floor. But as long as you don't contravene those, the legislation was there to encourage free and full discussion. So now you're going to try to exercise discretion. A big tech company exercising its discretion based on what you perceive as the viewpoint. Now, when I've looked at your material, I see that you said things like, big tech CEOs have proven themselves to be soulless oligarchs, and you blocked that.
Yes, Justice.
Don't we have to assume that there's an element of good faith here, and how do we ensure that that's the case?
Justice, as I mentioned, we deal with tens of millions of posts on a daily basis, and our moderators are human. There is going to be some element of overreach or under-inclusivity in our moderation policy. ChitChat makes a good faith effort to engage in moderation on the terms of its terms of service.
So that's just a mistake?
Yes, Justice.
Thank you.
Justice, we ask this court to allow our appeal, strike down the DPSA, quash the charges against ChitChat. To that end, we have 4 submissions for you today. First, I will submit to you that the DPSA infringes ChitChat's Section 2B freedoms by prohibiting viewpoint-based moderation. Next, I will submit that the DPSA further violates ChitChat's Section 2B freedoms by compelling it to host offensive and dangerous content. My co-counsel will then submit that the DPSA violates Section 15 of the Charter by protecting discriminatory speech online. And finally, she will submit that these violations cannot be justified under Section 1 of the Charter, as the DPSA is neither minimally impairing nor proportional in its effects. My first submission, which begins at paragraph 17 of the appellant factum, is that the DPSA violates Section 2B of the Charter by prohibiting viewpoint-based moderation of private social media spaces. The 2-stage test for a Section 2B violation was set out in Irwin Toy and requires the claimant first to show that the conduct in question falls within the protected scope of Section 2B, and second, that the impugned state conduct limits that protected expression in its purpose or in its effects. The appellant submits that viewpoint-based moderation, which the DPSA prohibits, is a form of expressive conduct which falls within the ambit of Section 2B protections. The Supreme Court has consistently held that Section 2B protections extend to a very broad range of expressive conduct. Moderation expresses ChitChat's political values and its corporate identity. Through its viewpoint-based moderation, ChitChat expresses its commitment to equality and civility in public discourse.
So, Mr. MacLean-Max, what would be different in the way you frame that expression in having the kind of disclaimers which the legislation clearly permits to indicate a particular post is at odds with those very values versus removing that post entirely? In other words, if the expressive content is moderation is how we let the world, or at least our users, know what our values are. And again, they may be idiosyncratic. We don't know that much about the definition of abuse or so forth in the day-to-day operations. You've already pointed to human error that can happen. So wouldn't the best form of expression to be when we want to say that this is at odds with our values? Say this is at odds with our values, and the legislation clearly permits that kind of moderation.
Well, Justice, we would submit that the best form of expression of our values would be to exercise our discretion within our privately owned space to remove that content which, in our opinion, falls outside the scope of what we want to see in public discourse.
But you haven't really told us, how are you going to decide whether something is harmful or offensive?
Justice, we have no bright line test for that.
Isn't that a problem, though?
Potentially, Justice.
It's basically, we're a big bad tech corporation, so trust us, isn't it?
To some extent, Justice. But in fact, we're not before you today to suggest that there is no scope for government involvement in the regulation of social media moderation. Chit-Chat welcomes government involvement. Our ideals, as my co-counsel will go into, align with the government in numerous ways. We also want to foster the broadest...
But you're not trying to change the terms in the Act. All you're doing is you're saying over and above the threshold that's set out in the Act, you want to add something. You want to add an exercise of discretion on the part of Chit-Chat to do more.
We're here to submit to you that the DPSA is a blunt, overbroad, and unconstitutional piece of legislation which should be struck down. What we would like to see instead is some form of far more sophisticated and nuanced collaborative legislation which will much more accurately and in a more tailored way address the complex social issue at stake here. And we in social media are well aware of the complexities involved in internet moderation. We've been doing this for a very long time now. And the government has arrived on the scene and implemented this very broad blanket prohibition on the exercise of this kind of discretion. And it is that blanket prohibition which we submit infringes Chit-Chat's Section 2B rights. My friends suggest that to extend Section 2B protections to moderation would be to trivialize freedom of expression. They point out rightly that virtually any human activity can be expressive, and they argue that as a result, almost any government action could theoretically be challenged under Section 2B. However, there is a principled way to determine whether the expression at issue is valuable enough to attract constitutional protection, and that is by considering its proximity to the values which underpin Section 2B. In Keegstra, the court held that 3 values are at the core of freedom of expression: engagement in political process, the search for truth, and individual self-expression. We submit that Chit-Chat's moderation is closely connected to all 3 of these values.
But how is censorship a form of expression? Is there any case law that you can take us to that would help us understand how you have come to the conclusion that censorship is a form of expression?
Social media moderation is a novel issue under the scope of Section 2B, but by analogy to traditional media, which have always enjoyed protection under Section 2B, explicitly enshrined in the protections for freedom of the press, I would submit to you that the exercise of editorial discretion, curatorial discretion, these are analogous forms of expression.
But isn't the problem there that curatorial discretion, editorial discretion are where staff of those bodies, newspaper journalists or radio hosts, are deciding what to put on their shows? I don't think Chit-Chat's taking the position that it has ownership of all the posts of the millions of users. Isn't this more akin, for example, to thinking of an analogous situation, the post office? And post office for a long time has banned obscene material from crossing borders. Is the post office engaged in expression when it decides some materials can't cross the border because they're deemed to be obscene?
No, Justice, but we would submit that we are in a situation much more analogous to newspapers or other forms of traditional media. True, we're not exercising discretion in the first instance, but we are deciding what to keep on our platform. The novelty here is the change in technology. It's not in the change of the discretion exercised. We are still exercising our right to curate content on our privately owned platform in line with our values and ideals.
But Mr. MacLean-Max, just to follow up on that point, unlike newspapers where there is actually sort of a voice speaking through the editor, through the writers, aren't you more of a conduit for other people's speech? You're not a speaker yourself. You're simply the carrier of other people's speech.
There are examples in print media of that kind of thing. The portion of newspapers given over to letters to the editor convey the expression of the public, not the intention of the editorial board. But I don't imagine that anyone would debate that newspapers enjoy protections under Section 2B to choose what to publish or not to publish in those sections. I would submit to you that the difference between our platform and a newspaper is, again, it's a difference of scale, it's a difference of technology, but that fundamentally, when we consider this in the context of the values under Section 2B, we're dealing with the same phenomenon. We're dealing with communications, we're dealing with the media of communications, and that private operators within that industry, within that context, have always enjoyed protection under Section 2B and related freedom of expression in other jurisdictions to exercise that kind of discretion. So our submission is purely that we be extended that same protection here. Barring further questions on that submission, I'll turn to my submission on compelled speech. So my second submission begins at paragraph 28 of the appellant factum, and it is that the DPSA further violates Chit-Chat's Section 2B freedoms by compelling the platform to host content contrary to its values. As established in Levine and further clarified in McAteer, Section 2B of the Charter protects both the right to engage in expression and the right to refrain from engaging in expression. To establish compelled speech, the claimant must first show that the compelled conduct is expression within the meaning of Section 2B, and second, that the impugned state conduct is intended to control expression, or if not, that the law has an adverse effect on expression. Just as hosting content is a form of expression.
Can you address the distinction, and you draw this out as your friends do in the factum, between association and attribution? Because coming back to my colleague's point, it seems the lowest form of association in terms of being the mere conduit as opposed to attribution. It'd be one thing if Chit-Chat put its seal of approval behind every post and says, we stand by this, its truthfulness and its appropriateness. But that's, of course, not what Chit-Chat does. It doesn't, I presume, take the view if someone defames another person in one of its posts that it's on the hook for any damages from that defamation because it owns every word that's posted. I would imagine it would take the position that we're just the post office and we have no control over or ownership of what's said on our platform when its liability would be at stake. So how is this its compelled speech? I can see the argument on moderation that you've put to us, that things you would otherwise take down, you're not able to take down. But in what way are you compelled to say anything in terms of the operation of this legislation?
I think there's a threshold between the post office example and the newspaper example. We are not a mere conduit here. We are a platform which is implicated in every single post that is hosted on our site.
But how are you implicated? Because you can put in, neon huge letters, we disavow these things. This is not in keeping with our principles. There's nothing to stop you from doing that. You just can't take it off. So you can disavow it. You can disavow it in the strongest of terms. You can say, this is not something that we either sanction or condone.
The speech we're being compelled to host here, Justice, is explicitly political speech. It is speech that conveys ideas that are antithetical to Chit-Chat's values. And we would submit that no amount of disavowal is sufficient to disassociate Chit-Chat as a platform with these kind of ideas.
But how is that consistent with, the whole reason why this legislation was enacted was to encourage free and open discussion to get to places you might not otherwise get unless you get the vigorous kind of debate that one has, and sometimes the debate is not as measured as it is in other cases, but you can learn from one another, even when you're having these vigorous kind of discussions and people feel strongly about things. And as long as Chit-Chat can disavow itself from some of the perhaps over-enthusiastic rhetoric, what's the problem?
Justice, I would submit that there are two separate issues at stake there. On the one hand, there is a question of how to balance freedom of expression against equality. And my submission is that that is properly dealt with under Section 1, and my co-counsel will address that later on. But the question of disavowal, the question of association, is a question under Section 2B itself. And the question fundamentally is whether the speech can properly be considered chit-chat such that by compelling it to host it, the state is controlling chit-chat's expression. And we have strong case law to suggest that the kinds of disavowal possible here may not be sufficient to create that association, to destroy that association, to avoid that association between the platform and the content.
But couldn't one argue that there's no way to understand those values if you're a user or a member of the public using the site because you can't see what's not there? Whereas if there is a post and a disavowal, then the values are made clear. So isn't the speech aspect really the disavowal piece? And of course, then there's accountability. If someone has in fact said something contrary to those values and gets canceled as a result, of course that can't happen if chit-chat makes the decision ahead of time to protect them by removing that post and potentially to protect itself from the reputational damage. So I get why chit-chat does this, but I'm not clear on how it's compelled to say or be silent when it again takes the position that it's not its messages, but other people's messages that are ultimately at stake and will rise and fall on that content.
There's no question that the messages of our users are the messages of our users, and chit-chat is not submitting to you that it is personally implicated as a corporation in the content of the speech. But as a forum, chit-chat has a right under Section 2B not to associate itself with certain kinds of expression, certain kinds of hateful, derogatory, powerful rhetoric whose mere presence on our site implicates us in its use.
Is this maybe not a stronger claim? The way you're framing it, are you suggesting there's a violation of the freedom of association more than speech, that you don't want to be associated with certain philosophies, ideals, points of view? Is this more of a Section 2D freedom of association issue as opposed to expression?
It's possible that there is scope to argue this under Section 2D. We've approached the issue under Section 2B because it is expression itself at stake, the expression of our users, the expression of chit-chat as a corporation. And association and expression are intimately linked. In Levine, we see discussions of association in the context of understanding what is and isn't compelled expression. So our submission is that the association made in the minds of the public between chit-chat as forum and the speech hosted on its platform engages the interests under Section 2B, engages our freedom of expression interests.
So how do we balance this, objective of ensuring that minority groups or disadvantaged groups aren't being treated unfairly and on the site, while at the same time making sure that Big Brother isn't there, making sure that nobody has a viewpoint except the ones that they like?
We don't know, Justice. We've been doing this for a long time, and there's no clear answer. But this legislation imposes a blanket prohibition. There is no tailoring. There is no nuance. There is no attempt to answer the question you've just posed to me. Chit-chat has its own answer. We've done our best through our moderation policy. We have these ideals of civility and equality in discourse, which we do our best to promote on our forum.
Except it's all trust me. There's nothing there to say, okay, well, unless it's discriminatory or unless it's racist or unless it's whatever, you don't specify or clarify what else you would be taking off.
We don't. And that's some place where there might be scope for government regulation to involve itself. But that government regulation, we would submit, as a pure matter of law, would engage our interests under Section 2B. And to be justifiable under Section 1 would have to engage in some of this thoughtful conversation that we're having right now. The DPSA has done none of that. We submit that it is reactionary and overbroad legislation. My co-counsel will address this issue more fully. But under Section 2B, my submission fundamentally is that the DPSA is unnuanced legislation aimed at this difficult task. My co-counsel will now submit that it violates not only Section 2B and chit-chat's freedom of expression, but also the Section 15 equality rights of chit-chat's users in a way which cannot be justified in a free and democratic society.
I just have one final question for you. I know that you've said in your factum that what you're seeking is that the act be struck down and that chit-chat's convictions be quashed. But so the act is struck down, but you don't actually want anything that's in the act taken out. You just want to add to it. Am I right? I mean, when we look at the provisions in the legislation, you're not saying, well, I don't want those things protected. I think what you're saying is, I want all those things protected and more, aren't you?
Certainly, Justice.
Okay, that's just a clarification.
We're looking, the fact is, the DPSA could be hardly more broad. Its exceptions, as my co-counsel will address, are simply in line with the existing law.
Right.
We're looking for something that moves beyond that
Right.
addresses this complex social issue and creates guidance for social media companies like ChitChat to engage with these issues in a way that conforms with Charter values.
Thank you.
Thank you, Justices.
We've asked you a lot of questions, but we appreciate your help. Thank you.
Thank you.
Ms. Goldfarb, whenever you're ready.
Yes. Thank you, Justices. I'll be continuing with the appellant's submissions on Section 15 and Section 1. Our arguments on Section 15 begin at paragraph 41 of our factum, and these submissions follow the two-part test that was laid out in Fraser. A claimant must show, first, that the law draws a distinction either directly or indirectly on the basis of a protected ground, and second, that the distinction imposes burdens or denies benefits in a manner that reinforces, perpetuates, or exacerbates disadvantage. The DPSA draws a distinction along the lines of race, religion, sexual orientation, and gender identity. It does so by preserving discriminatory content that targets these groups. Justices, prior to the DPSA's enactment, ChitChat would remove an average of 110,000 posts every day, much of which consisted of slurs describing minority groups and prejudicial stereotypes. The DPSA protects this content. It allows anyone to log on to ChitChat, tag an individual user if they're so inclined, and disparage them, mock them, deride them in racist or homophobic terms.
Well, I think we'd all agree that that is a very terrible thing to do to anybody. But we don't protect people from these kinds of harmful or abusive situations in conversations. We have laws that, as your friend has said, are very broad, and you know, we've got libel and slander laws, we've got hate laws, we've got other things. But we don't have the kind of thing that you're suggesting here. So why should we do that with social media?
Well, that's right, Justice, and Parliament has purposefully legislated a very high bar for what constitutes unlawful speech in general society by private individuals. And that's a very different context where the question is how much speech should be prohibited as a whole, full stop.
But why is this forum different?
Because here, Justice Thorburn, the question is how much speech should private social media companies be permitted, not even required, just permitted to remove within the confines of its own platform. And it stands to reason that that category of speech would be broader than the category of speech that is always prohibited, especially given what the Supreme Court recognized in Bragg, which is that social media is uniquely structured to magnify the adverse effects of hateful speech. It allows people to speak anonymously, which emboldens them from the safety of their keyboard, and it provides people with an extraordinarily large audience at their fingertips.
But I can organize a conference, and I can have 200 people in a room like this, and they can all be having discussions, and there's nothing to circumvent the sort of broad discussions, even if they're offensive in that context. And I'm still trying to understand, why do we need more in the online world?
Well, Justice, if that conference was run by a private organization, it would absolutely be at liberty to impose rules upon those attending. It could say, nobody is allowed within the confines of this conference to call someone else a racial slur. That's an entitlement that private organizations have. And the fact that private organizations impose rules within the confines of their space in order to prevent the prevalence of vandals or bad faith actors is not a per se evil. We have.
No, I was just going to ask you on that point because there might be some assistance to be had in going back to the trial decision in this case, and I think it was Dr. Mullins as the expert who testified, and the record is what it is, of course, when it gets to this level of court, but were there any findings coming out of that first level on the connection between the posts that are being compelled to be left up now, their reach, and that impact on groups and individuals that have Section 15 protection? Because I think fundamentally that's the key to the Section 15 argument in some respects.
Justice Sossin, we don't have statistics speaking directly to rates of exposure, but we have to consider the extraordinary scale we're dealing with here. We're talking about hundreds of thousands of posts containing prejudicial slurs and stereotypes on the daily and counting. There's a common sense inference in our submission that members of minority groups, as a result of the DPSA, have faced greater exposure to this content.
Can I ask you, Ms. Goldfarb, given that there's no limits or parameters on what kind of disclaimer you can attach to any message, and you're obviously in a position to filter what messages you would consider to be abusive, wouldn't a robust disclaimer alerting the reader to what is coming or what is behind that disclaimer with specific details as to why you find it as a corporation offensive, that it has racist content, that it has homophobic content, whatever it might be, as explicit as you need to be, to alert the reader, go elsewhere if you don't want to be exposed to this and we don't share these ideals? How does that not protect the groups that you're concerned about and prevent them from having the impact of this kind of content?
Justice Maxwell, that might protect those groups, and that is prohibited under the DPSA. The DPSA employs such an expansive definition of the term censorship that it prohibits any conduct on the part of chit-chat that limits the visibility of a post in any way. So if there were an alert saying, you're about to see a homophobic epithet, don't continue if that's going to harm you, that would come within the definition of censorship that's prohibited.
But you can certainly do what my colleagues suggested, which is to the first part of what she said, which is to say why you're not condoning it, what you find to be problematic, etc. And in suggesting that you should be able to block these things, aren't you denying people teachable moments?
Justice, to answer the first part of your question, in our view, it's cold comfort to the person being targeted with derogatory, racist, homophobic slurs that chit-chat says it doesn't condone that speech. It's the content itself that produces the harm. And Justice, to the other part of your question, the chit-chat's moderation policy, to the extent that it would remove initial racist, homophobic, transphobic content, does prevent people from responding directly to that content. But that's only a very narrow way of having a discussion about these important issues. Any person under chit-chat's moderation policy was absolutely free to log on to chit-chat and talk about something prejudicial that someone said in society and why it's wrong and why they think it's wrong, and ask what other people think about it.
So is it enough, coming back to some of the probing questions we brought to your co-counsel, is it enough to rely on the trust us in terms of the Section 15 rights here? In other words, has Chit Chat undertaken to ensure that no discriminatory posts would be allowed but for this legislation? Has it got a track record that it can rely on, that discriminatory posts haven't gotten through? Or is it simply based on Dr. Mullen's research that we know of the posts taken down, a good proportion, a majority, were aimed at groups who would, and individuals who would have Section 15 protection? Because again, there's nothing that I see stopping Chit Chat from changing its policy, modifying its understanding of what is discriminatory, harmful, abusive, whatever it might be. And in fact, Chit Chat takes the position in its submissions that it can't be expected to undertake complex legal analysis in every individual case. So isn't there a problem reconciling those two positions?
So I'd like to address a few parts of your question, Justice Sossin. The first is that there is a track record of Chit Chat's executive, Chit Chat's CEO, Charles Mackenzie, avowing a strong commitment to civil discourse and to the reduction of discriminatory speech. Chit Chat has invested a walloping amount of money in producing moderation schemes that are aimed directly at that purpose. Our friends haven't produced any evidence to suggest that that scheme is likely to change. And to address the other part of your question, which is that do we know if Chit Chat was effectively doing this beforehand? The answer from the perspective of Section 15 is that it doesn't matter. It doesn't have to have been perfect beforehand. Under Section 15, all that's required to be shown is that the DPSA requires Chit Chat to host more discriminatory content than it was hosting before. And I don't think our friends dispute that. Justices, we've discussed in part Dr. Catherine Mullen's testimony. I'd like to address it because Dr. Catherine Mullins discusses the deep psychological impact of this speech that we're talking about. She's found through her research that the effects of discriminatory speech include heightened stress, anxiety, depression, increased drug and alcohol use, pain, fear, and intrusive thoughts. This is an impact that in Keegstra, Chief Justice Dixon called grave and indisputable. In our submission, this is a clear case of adverse effects discrimination, and the goal of real and substantive equality demands a finding that Section 15 is limited as a result of the increased discriminatory content caused by the DPSA. Justices, if there are no further questions on Section 15, I'll move to my Section 1 arguments now, which begin at paragraph 56 of our factum. And I'm going to jump straight to the minimal impairment stage of the analysis. Here, the onus is on the government to demonstrate that a less impairing alternative could not reasonably have achieved its objective. In this case, the government has demonstrated no attempts to tailor this law, and therefore has no evidence that a less impairing alternative would be less effective.
Well, is that right in light of the fact that there are indeed exceptions? We've talked about the hate speech, unlawful speech, and speech relating to sexual abuse. So is it right to say that there is nothing tailored in this legislation?
Justice Sossin, those exceptions are what's minimally required to bring the DPSA in line with existing law. Without those exceptions, the DPSA would effectively force Chit Chat to abet criminal speech online. So that doesn't provide much in terms of leeway to Chit Chat.
So if you're going to quash this legislation, what do you propose that it be changed to? Other than I add my own discretion to add anything else I'd like to have blocked?
Justice Thorburn, in our submission, there are several ways in which this law could have been tailored without undermining its objective. The first is that the law was drafted to apply to an unnecessarily broad range of platforms. The definition of social media platform in the DPSA is so expansive as to include even platforms that were specifically designed to be a safer alternative to social media, for example, to serve children. As a result of the DPSA, any person can log onto one of those sites and attack a child on the basis of their race or religion or sexual orientation.
But we're talking here about chit chat and the charges against chit chat, and this is focused on the facts that we have before us. So I don't think we can really go off too far in terms of other situations. But I'd like to know, what is it that you would add? Because that's the concern from my perspective, is to say, this is a floor. I want to add something more. What is it that you want to add that you say will make it more effective and will protect those vulnerable people who use the Chit Chat website?
Well, Justice, I wouldn't purport to legislate from the podium, but we have seen plenty spheres of activity in which the legislature has managed to create more nuanced schemes in respect to content. For example, in the Broadcasting Act, there are different schemes related to what those who are captured by the Broadcasting Act can broadcast. That's not to say that we think that's the same standard should apply to Chit Chat, but it's evidence that Parliament can manage a more sophisticated approach.
Well, look, you wouldn't be the first to attempt to legislate from that particular podium, so you should feel comfortable. But I was a bit surprised to find the argument in your submissions that we ought not to bring the more relaxed Section 1 standard of looking for Parliament making a reasonable choice among difficult alternatives in social policy, complex policy questions, those kinds of settings. How is this not fitting exactly within that kind of distinction drawn in Irwin Toy and subsequent case law?
Because, Justice Sossin, deference is owed to Parliament when it balances various interests at stake. Deference is not owed when the issue screams out for balancing and the government demonstrates no attempt to actually engage in that exercise.
Well, that's not really fair. They have certainly attempted to engage in the exercise, right? They just haven't done enough, you say, to engage in the exercise. They've established some things that one cannot do and that would authorize Chit Chat to take down the posts.
And once again, Justice Thorburn, those things that one cannot do are already things that one cannot do. So there wasn't much creativity on the part of the government.
Although the disavowal, the disclaimer, isn't something they had to permit. They could have said every kind of vendor in the marketplace of ideas gets to hawk their wares without any interference from Chit Chat, and they didn't do that. They said Chit Chat's perfectly entitled to express its values, to shout from its rooftop, as long as it does so in the form of a disclaimer, not in blocking, banning, censoring. So how is that not striking the kind of balance that you say is cried out for in this circumstance?
Well, perhaps it provides some evidence of an attempt at balance, and perhaps it weighs on the Section 2B analysis, but it certainly does nothing to quell the effects of the increased discriminatory speech under the Section 15 infringement. And Justices, this principle, I believe, came from Hutterian Brethren, or was communicated in Hutterian Brethren, and there the Alberta government consulted with the Hutterian colony. It offered alternative solutions to the photo licensing scheme that was infringing their rights, and the Hutterian colony rejected those schemes. There we see an attempt to grapple with the different interests at stake. Social media platforms are experts in moderation. They have been engaged in the process of developing these incredibly complex moderation schemes for over a decade. And yet the government made no attempt to consult social media platforms in order to discern what really makes an online space hostile and what really makes it productive and healthy and constructive.
Except that, and I appreciate that they have experience in doing this, Chit Chat and other sites. So and I appreciate that you're not the government passing legislation, but I'm still looking for what are the proposed solutions to this problem. I want to exercise my discretion. I'm the big tech company, and I want to decide what people are going to see and what they're not going to see. And that's a problem, I think, when one looks at the objective of the legislation being the promotion of free expression. So in order to balance the legitimate desire, I think, and something that's in the public interest of promoting free expression and free-flowing ideas and discussion, and while at the same time protecting these things, there has to be something, I think, that you can point to which would help us, other than the subjective, well, let me look at it, I've been doing this for a while. Well, what are those suggestions?
Well, Justice, I see I'm coming just to the end of my time, so very briefly, the alternatives would be either a more sophisticated substantive test that identifies a category of speech that attacks people on the basis of protected grounds. Again, it wouldn't be easy to craft that law, but it's necessary. And the other alternative is a procedural mechanism, some form of appeal for individuals who feel that they've unjustifiably been banned or their content removed. Justices, I'm at the end of my time, so I'll conclude by saying that Chit Chat asks that this law be struck down. It's unconstitutional and it's unnuanced, and we ask that Chit Chat's charges be quashed. Thank you.
Thank you very much.
Thank you.
All right, the respondents. Ms. Hsu? Will you be following the same format as your friends, and you'll begin with the Section 2B?
Yes, that's
okay.
right. May I begin?
Whenever you're ready.
Good evening, Justices. My name is Ivy Hsu, and together with my co-counsel, Adrianna Mills, I represent Flavel. This appeal is not about the scope of permissible speech in public, because we already have laws that regulate speech, such as the Criminal Code, human rights legislation, and tort law. These are the product of complex balancing by an ongoing dialogue between Parliament and Flavelian courts. This appeal is instead about a much simpler question, which is whether the Charter protects a corporation's ability to impose its own rules of speech in a public forum. The answer to that question must be no, for 3 reasons. First, restrictions on social media censorship do not infringe Section 2B. Second, there's no infringement of Section 15. And third, if this court finds any infringement, it is demonstrably justified under Section 1.
Would you agree, though, that this has to be looked at through the context in which the Charter was enacted?
Yes.
Okay. So you don't take issue with the fact that we need to look at this to ensure that vulnerable communities, minority communities are protected?
I don't take issue with that, but I would like to point out that such balancing has already been done through jurisprudence, through legislation, in the past and ongoing. Okay. And what my friend is asking for is for this court to legislate in the stead of Parliament by imposing rules that Parliament has chosen not to impose. And on Section 2B, are we making 2 arguments? One is that the Montreal test must exclude social media censorship from the protective scope of 2B. And second, in the alternative, the DPSA's effect on Chit Chat's expressive freedom is merely incidental. And now I would start with the first argument on the Montreal test, which starts...
It's just as you're joining the Montreal argument, help me understand how a place-related set of principles engages social media. We refer to it as a digital space colloquially, but clearly there were physical elements to the court's concern in Montreal. Are those an easy fit for the chit-chat context in your submission?
Yes, they are. The reason is because the same kind of principles would apply. And the first part of the Montreal test about the conflict between the form of expression or method of expression and the function of the forum still readily applies, whether it's in digital sphere or in physical spaces. And the factual record in front of you demonstrates how antithetical corporate censorship is to Section 2B's purposes. Chit-chat has censored, as Justice Thorburn you mentioned earlier, criticisms of big tech CEOs. It has also censored posts about controversial court rulings, allegations of corruption, and discussions of various public policies. My friends write that Section 2B is broad in its scope, but it cannot be so broad as to render the freedom of expression guarantee meaningless. And the Supreme Court recognized this when the majority developed the Montreal test by analogizing certain methods or forms of expression to violence, which has always been excluded from 2B.
So just on that point, because this analogy comes up in your factum, do you not find the analogy between violence and hate speech to be more apt than an analogy between violence and censorship? I mean, hate speech, however it's defined or characterized, one would say arguably doesn't advance the pursuit of truth, and in that sense is more analogous to violence. It doesn't fulfill, it doesn't serve the object of self-fulfillment. It doesn't promote positive, healthy discourse. So the analogy, and censorship is sort of it sounds like a very value-laden term. It has negative connotations to it. But fundamentally, you pointed out some of the things that chit-chat was censoring. But they were also censoring low-value speech that was filled with racist, homophobic, and other types of comments that generally are denounced. So is it not more akin to the violence, isn't the analogy more apt between violence and hate speech and what chit-chat is trying to get out of its form?
No, Justice Maxwell. The reason for that is because Section 2B must be content neutral. And what that means is that hate speech, even hate speech, is protected under Section 2B because it's problematic due to its content, whereas violence or censorship are problematic due to their form. And that form is problematic because it directly suppresses other people's expressions. And it's hard to think of anything that is more antithetical or contradictory to what the protection of free speech must mean. And that also leads me to an issue with my friend's approach, because my friend essentially ignores this principle of Section 2B being content neutral. They would look at the meaning of the expression and how censorship can be used to promote valuable meanings. But the same thing can be said of violence, because one can express important values of equality, of protection for minority groups through violent acts, but that does not bring violence within the ambit of Section 2B.
Doesn't Irwin Toy set a very low threshold?
Yes, and it's our submission that censorship does not even pass that low threshold, both because it is directly contradictory to Section 2B values, but also because it is not a expressive or communicative enough form, and I will get to that later.
But surely expressing corporate value through your moderation policy is an expressive activity, isn't it?
It is, in the same way that violence could be expressing important values. But at this point, we're focused on the form of that expression. So it's open for chit-chat to display a disclaimer or express its values in any other way. It is simply cannot take the form of censorship. And the content-neutral principle has animated the structure of analysis that we see in much of this court's 2B jurisprudence. So if the government passes laws that suppress misinformation or
offensive speech. Those are clear Section 2B infringements, and they will have to be justified under Section 1. But when a private actor censors a post, there is no justification, no balancing of competing social interests, and not even an obligation to give any reason to the author of the post. And Section 2B cannot be used to protect something that is so contradictory to the basic structure of charter protection. I understand my friends wants to protect good faith content moderation, or an attempt at balancing competing social interests. But the point here is that there is no accountability mechanism to ensure that all platforms do exercise good faith. And there is nothing to ensure that chit-chat itself doesn't change its moderation policy. In fact, it could be under the threat of a hostile takeover tomorrow by a certain billionaire who makes rockets and electric cars and has a very particular view of what public discourse should look like.
But doesn't that argument, evocative as it is, cut against some of your reasoning as well? Because if it is idiosyncratic, if you don't know what that moderation policy is going to be tomorrow, doesn't that speak to how it is a form of expression? It's not simply the workings of, an automatic or automated process. It's an expression of either the individuals involved or those who they take their marching orders from, and as low value as that kind of expression may or may not be, the low threshold established arguably is clear precisely because it's an expression, idiosyncratic and evolving, of this company's wishes. And again, the ship has sailed on whether things like advertising and other forms of corporate speech are covered. Why should this form of corporate speech be any different, as challenging as corporate behavior and those who are the face of the company might be?
Justice Sossin, a corporation or any private individual on their own, they are free to express any idiosyncratic values of, that they might have. But the problem here is that they cannot use their values to control what other people can say in a public forum. And I think that leads to an important distinction in this case, which is what is a public forum and why social media is so important in our modern democracy. And under the location factor of the Montreal test, I think social media's function is to allow everyone to express themselves. It is different from a private individual in their own home who are free to do anything. It is different from a newspaper that pre-selects content before publication, as Justice Sossin and Maxwell, your questions to my friend, pointed out. It is different from a private club that screens people before admitting them into a membership. It is a kind of forum where precisely not a single person should have the power to decide what everyone else can do or say. And it's because of that open access feature of social media, it has become the quintessential public forum.
But aren't they already, democracy. I mean, the provisions in this act already give them the power to block certain things. So there are an enumerated number of things that if they're found in these posts, they can be blocked. Why should we not also be adding things like misinformation and discrimination? Aren't those obvious things that would be, because I understand your point about, well, it's subjective and who knows who's the hostile takeover and who knows, what might happen and the good faith issue. But surely those are pretty easy to add, aren't they?
No, Justice, and my co-counsel will get into this as to why the legislation must be written the way it is, and any kind of additional exceptions would fail the DPSA's purpose in bringing public forums such as social media in line with what Parliament has legislated, with what this court and Parliament has together decided to be the line between permissible speech and impermissible speech.
But why isn't it open to a corporation that, again, no one has to go on and engage with, to say, if you want to go on and engage with us, you have to agree to our terms of service. You have to hit agree. That means 140, or used to mean 140, and not an unlimited number of characters. It means you can't use, and we could insert, these 15 words and make it very transparent because they're offensive and inappropriate. It may mean that you can't engage in certain other kinds of speech, like the kind the legislation itself recognizes. That can be set out. How is it any different to say that your eyes are open if you use a service, that it could be subject to this review by the company for grounds that it communicates in, again, a fairly general policy, maybe even opaque, but it's not arbitrary, it's telling you the categories. Why isn't it open to the marketplace to work its magic, and those who don't want to participate in that kind of forum for speech can go to the town square, get on a soapbox, and shout to their heart's content?
Justice Sossin, 2 responses to that. The first thing to say is we are talking about a kind of legislation that seeks to bring people together, to have an exchange. So it's useless to say that you can open your window and shout your opinions outside because no one would be there to engage with you. So this kind of legislation does not depend on the fact that users might find alternatives elsewhere. It would defeat the purpose. The second thing to say is the Parliament has taken up an issue with censorship in and of itself. So the answer for someone, for example, if you are discriminated against by an employer or a private landlord, the answer cannot be that you should go elsewhere to find housing or find alternative employment. And there's a further analogy that I want to draw here, which is private businesses have always been required to exercise their private contractual rights in a way that is constrained by certain public law values. And we submit to you there's nothing unusual for the DPSA to say that you cannot contract around these type of regulations through terms of service.
Aren't you really, though, then running the risk of having people, and in the modern day, everybody uses social media, and if these posts are there, you're actually preventing people from being part of the discussion at all because they feel vilified, discriminated against, hated, and so they really are being precluded from being part of the discussion at all.
Justice, I would push back on that characterization of digital space because on social media, much like in the physical space, when you see someone that you don't like, you tend to walk around them. On social media, the equivalent is most of us do not befriend or follow people that we don't want to engage with. So there are essentially separate spheres of engagement where I am personally, and I think quite a lot of people are not necessarily exposed to remarks that they fundamentally find offensive or egregious. So the fact that in the vast digital space, someone somewhere is saying offensive things do not really affect my ability to use social media as a public forum.
But doesn't, I mean, practically speaking, the scope of the DPSA kills the idea of sort of a safe place to speak about ideas in the sense of, as your friends were pointing out, sites that are specialized to particular interests, particular groups. If you had, for example, a site that was dedicated to survivors of sexual assault to exchange ideas, exchange experiences, and ways that they have recovered. That sphere could be penetrated by those who have opposite views about the laws around sexual assault or the laws that relate to victims' rights or anything of that nature. So the concept of having sort of a safe space for the targeted group becomes really unattainable because that sphere can be infiltrated by those who wish to express their view, but with content and in a manner that is completely counter to the objective of the group and the space that they're trying to create. Is that not really what the scope of this legislation truly does? Is it removes that possibility?
Well, Justice Maxwell, my co-counsel will address it more in depth in terms of the harm and how those balance with the positive effects of the legislation. But the short answer is that Parliament is also concerned about preventing installation of fringe rhetoric. So there could be a sexual survivor group that were penetrated very unfortunately, but also at the same time, it also means incel forums and other kinds of forums are less likely to be able to talk among themselves and hide themselves and never be challenging their views before it escalates into something more dangerous. And if my first argument on the Montreal test does not convince you, you can still find for the respondent regarding the effects of DPSA. So we'll turn there now, which starts from paragraph 41 of the respondent factum. The Irwin-Toy test requires that the expressive conduct itself must promote the core values of Section 2B, so that the law doesn't just incidentally affect freedom of expression. And to meet that test, there is often a minimum threshold of communicative potential that has to be met. And the reason for that is because, again, Section 2B is content neutral. So the argument cannot be that the meaning being conveyed promotes the core values of 2B. This step of the test has to be about the form of expression and whether that form is capable of promoting public discourse. And in case law, the form often needs to convey or carry some kind of public benefit that relates to the flourishing of public discourse, such as the fact that advertisements on buses tend to promulgate the message to a large segment of the public, as in Greater Vancouver, or that news reporting facilitate broad public access to information, as in CBC, or on Justice Abella's view in City of Toronto, election campaigns are not just about individual candidates expressing their personal political opinions, but more importantly, they are capable of triggering a series of electoral expressions with the voting public. And censorship is a very different form of communication. I see that I am nearing the end of my time, if I may just wrap up this point.
Certainly.
There is no public promulgation because most users would not even see the original post or know that chit-chat has expressed its corporate values this way. And there's no public engagement because the post simply disappears before much dialogue can happen. And when chit-chat censors a controversial opinion, it also removes other users' responses to that opinion that challenge it and points out why perhaps it is wrong. The Supreme Court has repeatedly held that Section 2B is not without its limit, and the government should not be required to justify every regulation of a form of expression. And censorship is exactly the kind of conduct that should not be protected so as to trivialize the freedom of expression guarantee. And I'll leave it to my co-counsel to address Section 15 and Section 1.
Just before you leave us, and again with some latitude on time, I was just hoping for a very quick response to material you haven't been able to get to fully in your oral submissions, but is found in your factum on this issue of equivalence. That, and you pointed out this in response to Justice Maxwell. It may be harmful in the survivor group, but helpful in disrupting the incel group. And you have in your factum references to, while chit-chat may be associated with abusive posts on the one hand, they may be associated as well with posts on the other end of that spectrum, or the opposing views. But do we really look at speech that way? Was that, for example, the approach in Levine? If the union was spending funds on lots of things that represented all the members, it was okay that they also spent on some aspects that members felt vehemently against? Do we simply look for equivalence, or are we concerned with whether the speech can negatively affect the reputation, negatively affect the brand, negatively affect the forum?
The latter. So the fact that the posts that were being censored fall on a broad spectrum is more important or more relevant to the purpose analysis, in the sense that the DPSA doesn't affect the expression of just one type of meaning. It could be about any kind of corporate value or any kind of meaning. But at the public association stage, it's more about whether users would harmfully attribute that message to chit-chat.
Okay, thank you.
Whenever you're ready, Counsel.
Good evening, Justices. I will be addressing the second two issues on this appeal. First, the DPSA does not infringe minority groups' right to equality under Section 15.1, and this issue begins at paragraph 62 of the Respondent factum. The appellant has failed to establish that the DPSA causes harm to members of minority groups, and the issues with its claim are twofold. First, the appellant's claim of causation hinges on the assumption that censorship policies across different platforms will actually protect members of minority groups. And second, the appellant has not met the requisite threshold of harm in relation to an increase in offensive posts on its own platform. And as you stated, Justice Sossin, outreach and impact are key for a Section 15.1 finding. The respondent's position here is that the cumulative effect of establishing a Section 15.1 breach on such a tenuous basis of harm would lower the threshold required for a finding of discrimination such that there would be no meaningful test. First, Justices, it is not discriminatory to fight content discrimination. Chit-chat is only one of several dominant social media platforms in Flavel. And one of the benefits of speaking last today, probably the only real benefit, is that this court has heard examples of both positive and negative forms of censorship. And there is nothing about censorship that is inherently beneficial for minority groups. And in fact, historically, the groups that have been subject to the most harm from censorship are the very same as those enumerated grounds my friend appears on behalf of today. In Little Sisters Art Emporium in Canada, for example, Justice Binney found that the disproportionate prohibition on queer erotica violated Section 15.1. At the same time, he explicitly recognized that vulnerable groups are particularly susceptible to overzealous censorship. Further, as laudable as Chit-Chat's goals for its own platform may be, any protections it affords members of minority groups cannot be guaranteed in future. Social media is a rapidly evolving industry, and Chit-Chat may not always be a dominant player in this market. As my co-counsel pointed out, the CEO, who may have good intentions, could change any time. And in fact, censorship on the platform is already in flux. As recently, Chit-Chat has experimented with outsourcing its discretionary censorship policies to external corporate partners.
But how do you address your friend's point at paragraph 52 of their factum when they say that by shielding offensive content from moderation, the Act gives exposure and lends credence to discriminatory ideas?
I have 2 points in response to that, Justice Thorburn. So in this case of causation, my purpose is to draw attention to the fact that not all platforms may censor in the same way that Chit-Chat does. And a broad view of Section 15, considering that substantive equality has to take into account the full situation of a claimant's background, is that there are other platforms that may censor in the complete opposite.
Well, just as we're, again, not going down the pathway of harm to children on other sites, compelling as that concern is, shouldn't we also stay focused on what Chit-Chat is doing, even mindful that the effects of the DPSA may differ in platforms? Again, Justice Salamat made a finding that the effects of the DPSA are not experienced uniformly across the Flavelian population, and members of minority groups bear the burden of the unfiltered and unmoderated expression more than others. Isn't that the mountain that the respondents have to climb, given that she was exposed to the expert evidence and the record as it's set?
I take your point, Justice Sossin. On the causation issue, the other point in relation to Chit-Chat specifically is that there is a weak nexus of causation for Chit-Chat, because in some the claim is resting precariously on this one moment in time. But even if that is not enough to prevent a Section 15.1 breach, the second issue is that Chit-Chat's claim has not met a requisite threshold of harm for a finding of discrimination.
Just before you go into that, I wanted to follow up on my friend's, or my colleague's point that we're only dealing with this specific fact situation, but even if we weren't, isn't it absolutely inconsistent with the purported objectives of the Act that we be creating silos of viewpoints? I mean, isn't the whole point that we have a fora like this where people can engage in a whole variety of topics from a variety of perspectives in a civil and respectful manner? And by saying, oh, well, there's another site over there, the neo-Nazi site, well, you can go over there if you like that one, and here's the, you know, the Marxist-Leninist one over here. Well, how does that doesn't promote free discussion. In fact, it's antithetical to it, isn't it?
Justice Thorburn, I completely agree, and I will return to this under the Section 1 analysis. My only point in mentioning the other platforms is to show that the test under Section 15.1 is basically, is the DPSA going to harm minority groups more than the alternative? And the alternative is unfettered censorship across all platforms. And the DPSA was enacted to address the fact that these policies may vary.
Although I think what your friends were saying, if I understood them correctly, is not unfettered. Yes, they would exercise the discretion, but they have articulated certain objectives, such as ensuring that vulnerable groups are not taken, advantage of, they're not disparaged, and to deal with discriminatory posts about minority groups. So they have articulated that.
Yes, so what I mean by unfettered is not that there are no terms of service, but that the discretion is completely unfettered and there was no regulation prior to the enactment of the DPSA. To return to the point of a finding of discrimination, Justice Abella emphasized in Fraser that the pertinent question for discrimination asks what the law's effects are in practice. And yet we cannot merely infer harm when we have no contextual information about the nature of the posts that would otherwise have been censored. So for example, ChitChat uses proprietary technology which censors on the basis of words or terms alone. But the issue with such a blunt approach is that it does not capture a distinction between when offensive speech is stated at first instance versus when it may be shared and repudiated. It also would not account for satire, for comedy, for the reposting of song lyrics, or even the cultural reappropriation of terms that were once offensive.
Doesn't it, though? Isn't that exactly where the exercise of discretion kicks in?
No, Justice Thorburn, unless an individual actually appealed their post, in which case the appeal process is entirely internal, this proprietary technology is used in conjunction with compliance teams, and individuals would simply not see their post at all. And yet, even if this court accepts that there is an available inference that some of the content in these posts are directed at minority groups, and the available inference that someone would have seen these posts, to conclude harm requires another evidentiary leap. And the only evidence presented by the appellant that speaks to the nature of potential harm is the testimony of Dr. Mullins. Not only is Dr. Mullins' testimony inconclusive, but it also doesn't speak to the possibility of differences between speech on and offline. For example, in College of Physicians and Surgeons and O'Connor, which was a decision decided by the Superior Court of Justice just this year, the court asserts that the use of outrageous language has lost its intimidating nuance in the crude mirror of our culture that is the contemporary media environment. In other words, it is the exaggeration and ubiquity of offensive speech on social media platforms, as distinct from speech in person, that may well dilute the harm of an individual post.
Doesn't that result in a kind of reductionist argument that as bad as social media is, the world's even worse? Is that really an argument on which to build a response to Section 15, particularly in light of Fraser, in which Justice Abella cautions against using the record and the evidentiary requirement as an insurmountable barrier for effects-based discrimination claims under Section 15. Here, there doesn't appear to be a contest around Dr. Mullen's testimony, and she's a well-respected sociologist, and the harm that she's speaking of is significant. We've got a first instance judge who's found this effect disproportionately in minorities. Doesn't that add up to, in effect, crossing that threshold from Fraser?
I'll speak to a few points that you've made there, Justice Sossin. So first, it may be a fair criticism of the Superior Court of Justice's decision here, but to clarify, I'm not relying on this decision to state that this is necessarily the case or the correct evidence to look at in this case. Rather, I am drawing attention to this because it shows the difficulty with making inferences on case law alone and without an evidentiary record. The issue with Dr. Mullen's testimony is not that I don't accept or I have no dispute that the kinds of harm she has listed are real harm, but it's that it is not conclusive and that it doesn't speak to the actual circumstances of this case. And further, as you put it...
Well, but the actual circumstances of this case change minute by minute because you're getting tens of thousands of posts every single day. But what we are looking at is that surely what it seems to suggest is that as we go forward, there is a real risk of real harm.
What I mean by the circumstances of this case is that it is in relation to speech which is on social media, and Dr. Mullins is not speaking to the nature of speech on social media. Further, as you put it, Justice Maxwell, to my friend, there is no accounting for what effect a public disavowal may actually have on this speech either, whether that dilutes the harm or even benefits public discourse.
And I appreciate your comment about the thing saying we disavow this, etc., for whatever reasons. But surely the purpose of the act isn't helped by protecting invective.
I would agree that the purpose of the act may not be furthered by certain kinds of speech that it does protect. And I will turn to that more at Section 1. I'm just going to briefly conclude here on Section 15. And that is that it is my position that it's this weak nexus of causation and harm, coupled with the lack of the evidentiary record of real harm, which is precisely the web of instinct that the Supreme Court in Te Potat cautioned against grounding a Section 15.1 claim. And subject to any further questions, I'll turn to Section 1 now. As the appellant has conceded the first two steps of the Oakes test, I'll go directly to why the DPSA is minimally impairing. And this begins at paragraph 75 of the Respondent factum. The limit imposed by the DPSA impairs the rights of the appellant and of minority groups as little as reasonably possible because the DPSA must be broad in order to achieve its legislative objectives. And to return to your question, Justice Thorburn, about offensive invective, it is imperative at the outset of the Section 1 analysis to consider what is the alternative to the DPSA as written. My friend's suggestion that the ideal alternative would include, at the very least, collaboration between Flavel and social media platforms misunderstands the point of the Act. The DPSA was enacted to protect social media users from the whims of corporate censorship and to protect freedom of expression from their competing aims.
But don't you yourself indicate what more minimally impairing steps could be taken in the way you characterize the issue in that paragraph you took us to, 75, where you say corporations like ChitChat are unaccountable to the public, they are compromised by profit motivation, and their censorship policies are opaque. Well, each one of those issues can be addressed through legislation. In other words, if they're unaccountable to the public, your parliament, make them accountable to the public. If they're undermined by the profit motive, if they're not transparent, require transparency. Require every decision to come with some explanation of why something has been deleted or why it's viewed as harmful or offensive or abusive. All the things you complain about as requiring the broad prohibition could in fact be much more targeted in legislation that, again, Parliament's chosen not to undertake, just as it chose not to consider platforms like ChitChat as broadcasters, which would bring them under the Broadcast Act, which is a highly regulated environment by Parliament. So aren't these the the challenges for the respondent to say, well, because of these risks, we need a broad prohibition, when each of those risks are fully within Parliament's authority to deal with.
Justice Sossin, I acknowledge that it is incumbent upon the respondent at this stage to outline why there are no reasonable alternatives. And I am going to go through three specifically, which, as you mentioned, are in my factum. But in terms of a completely different act, which wouldn't include a further carve-out or exception, my submission is that is not a reasonable alternative to impose an entire regulatory scheme. So while it may be appropriate, for example, to have an external tribunal or an external appeal process to rectify individual claims or remedies, the purpose of the DPSA is to fundamentally shift public discourse online. And the purpose is to have a prohibition, a broad prohibition against viewpoint. And so I will turn now to three alternatives that do arise from the appellant's argument, and I'll explain why all three are inadequate. First is that an exception for offensive speech would in effect be to revert back to the censorship policies that were in place prior to the DPSA. Second is an exception for misinformation is not feasible. And third, an exception for particular forums would encourage isolation of views. And in fact, the DPSA was enacted for the precise purpose of rectifying siloed discourse. So first, an exception for offensive speech is untenable. And I remind the bench here that Chit-Chat's previous terms of service allowed it to censor any posts that were harmful and abusive. While this policy may have restricted posts that contained offensive speech, it came at great cost to freedom of expression. And in fact, operating under a highly restrained version of this policy, Chit-Chat found the following posts to be harmful and abusive. Post about a controversial Supreme Court ruling, a post criticizing the current premier, a post from animal rights advocates, a post criticizing those who did not vote for the current government, and a post containing anti-corporate speech.
But do the exceptions prove the rule? Those were characterized as outliers and the product of human mistake, at least one of them. Shouldn't we be concerned with the overwhelming preponderance of the moderated posts that were deleted, which were because of harm and offense, and not the exceptional ones which certainly seem to stray very far from those bounds?
No, Justice, and that is because this is actually a restrained version of what Chit-Chat was exercising prior to the DPSA. So what we know is that in the first 24 hours after its enactment, Chit-Chat censored posts that contained political expression. Now, whether or not that was by accident or on purpose, is irrelevant to the question of how that censorship policy infringes on freedom of expression.
But are we dealing with whether there should be discretion or how discretion ought to be exercised? Because I appreciate that you don't like the way that they've exercised their discretion, and whether there are a couple of outliers or whether it's more serious than that, we don't know. But really that problem is the exercise of the discretion, not whether there should be any discretion with some sort of oversight or some other parameters given to ensure that those kinds of things don't happen.
That's correct. And when the record shows that a corporation like Chit-Chat was not exercising its discretion in a proper manner that balanced the freedom of expression of all individual users, that is why the DPSA is necessary.
But then the solution, I suppose, would be what Justice Sossin was suggesting, which is that you as or the Parliament is able to put in framework that allows for greater accountability so that the exercise of discretion is done properly, or that the corporation is held accountable. So is it really the case that trying to carve out an exception for offensive speech or misinformation is so untenable if you partnered that with Parliament, in theory, just also putting in more accountability measures to make sure that that is in fact what's being filtered out?
Justice Maxwell, I submit that there already is a scheme, and that is jurisprudence and legislative schemes that have been in place through Parliament and these courts.
But we know that they don't cover things like discrimination. We know that they don't cover you know, other types of things that we all seem to acknowledge, at least from what I've heard from your friends and from your colleague, are problematic.
I see that I'm out of time, if I may have a brief indulgence to
Certainly.
answer your question. I agree with you. However, Parliament has drawn a line here to only include those carve-outs where there is existing jurisprudence to guide corporate discretion, and not to include a carve-out that would rely on corporate discretion alone. And that means is owed deference here under minimal impairment. And to conclude briefly, the rise of social media has transformed public discourse. And online platforms have supplanted the original public squares. The DPSA ensures that all individuals continue to have equal opportunity to partake in public discourse as they do in physical spaces. The appeal should be dismissed. Thank you.
Thank you very much. Yes. We're going to retire for a few minutes, and then we'll be back with you. Thank you very much. Well, welcome back. It is wonderful to see so many new faces and some old faces, former students and clerks of mine. So it's wonderful to be here with you today. And I don't like using the vernacular usually, but I just want to say, wow, you were really, really, really good, really prepared. I heard a vicious rumor that some people were in here practicing on a Sunday, and boy, it really shows. So you were terrific. We don't have a lot of criticisms because your performance was excellent. I think all three of us were saying we wished we had such great counsel before us every day. But I guess the reality is that when you get into real life practice, you don't necessarily have the luxury of preparing as well and as thoroughly as you have, but I think these will give you the tools to do that when you do that. I also think it's an opportunity for you if there were things that you thought you might want to do differently, or you thought about doing, and what did we think about perhaps you doing. This is an opportunity for you to ask us some questions as well. So what we thought we would do is we'd start off, each one of us just giving you a couple of points about things that we thought were particularly good, or things that little small points that maybe we could do, you might want to think about doing differently the next time. So maybe, Lorne, do you want to start?
Sure, and again, what a pleasure to see the talent and hard work and passion for advocacy on display. So it was just a pleasure, ice in the veins, warmth in the heart. Everything that you could have come here expecting was present and accounted for. It's a challenging thing when you know you're going to get questions right off the bat, and you're there ultimately to tell a compelling story. And I think each side had real challenges in how compelling their story could be, and each side had a kind of big brother problem. The sort of idea of the corporation knows best is hugely problematic. The idea that the government is your friend and just looking out for, the free exchange of ideas generates a lot of skepticism. So, I thought you did a good job on that storytelling and focusing on, how to link up with the inevitable challenging questions that were going to come on whether this is really about free speech. The questions, and I think this is hard to keep in mind when you're there and you've got, the story you want to tell, and sometimes the questions are taking you off it. But it's always great just to see every question as this gift. You're being shown this transparent window into the mind of the decision maker and what's top of mind. And each of you, in your own way, had some pushback moments, as you should, not to give in if you're asked a hard question. Isn't this like the post office? The answer should be no, it's not like the post office. Or isn't this government overreach? No, that's not what this is about. This is about preserving that free exchange of ideas. But again, I think there's the challenge of how to do that in ways that convey engagement with, and in that sense, thank you for giving me this sense of what's on your mind, and here's how I'm going to use that to make my story even more compelling. And I think that's something that we see lawyers every day struggle with, and many struggle with far more than the four of you did today. So it's great to see that's already in your minds. And the recipe is, I think, a simple one. It's really knowing your material inside and out, the run-throughs, the practice sessions on the weekend, everything really pays off in that comfort level with being on your feet. And I think we were really impressed and felt like we were having this conversation about what was important to us about your cases, even if that meant you had to truncate material, skip issues, go out of order. And that's just super difficult to do when you have everything as tightly organized and in a structure as you inevitably do. So I really enjoyed it. I think, again, that will be a journey you'll continue on in terms of how to strengthen that sense of using the questions to pivot in the best possible way to the strongest aspect of your arguments. And I was super impressed by what we saw, and I hope everyone appreciated all the different aspects that went into this particular case. It's like the iceberg that we're seeing just a little bit above the waterline. We, as the judges, got to read the factums, which are terrific, and the problem design, which was crisp and full of richness and texture. So all that work was wonderful to see.
I absolutely would echo Justice Sossin's comments. You were all tremendous. And I can say that, as somebody who has advocates that come before me every day of varying quality. It'd be brilliant if they were all like you. I can also say it as a former Grand Mooter myself. You were amazing, amazing, amazing. I remember being very, very afraid when I did it, and I'm sure I was nowhere near as good as all of you were. But I can certainly relate to how you're feeling, and I can say that it was extraordinary. You were really, really comfortable with your material. You knew the cases extremely well. You knew your facts extremely well, and you all four showed real comfort and versatility in answering the questions, in pivoting from where you were because we were taking you somewhere else, and not getting thrown off by that. I think that as Justice Sossin was saying, both sides have strong arguments and then areas that are more difficult to persuade on, and that's both sort of on the law, but also just sort of on the narrative, right? And I think all of you did an extremely good job with finding the best way around the more difficult questions or the not so attractive parts of your narrative. I think it's always very important to just deal with those kind of things right up front. It's okay to tell the panel or the justice that you're in front of, either in response to a question or just on your own. I know, no one wants the government to, have their thumb pressed down on our ability to speak freely. Or we know that, corporations, big bad corporations, that's the way the public sees them. But, we're here to assure you that there's value in letting corporations manage this area. You can kind of dull the impact of where your friends are going and where the panel might be, just sort of in terms of what we might be thinking about is problematic about your positions. You can take that on right out of the gates and give us a sense of ease and comfort that you recognize the parts that maybe don't sit as well with the public or maybe with any of us, but you're here to assure us that you're going to get us to the right place at the end of this argument. So I thought, all of you understood your narratives very well, and don't be afraid, don't shy away from just taking the ugly bits and the parts that, maybe have a few more tentacles that are not as pretty to deal with and are probably going to come up in questions. Maybe take those on right away and just get us settled, get us calm about the fact that what we're thinking, but it's okay. I've got you. I'm going to get you there. So honestly, wonderful job. You will all be an asset to all of us when you're litigators in our courts. So thank you.
Thank you. And Ms. Mills, I know there are lots of disadvantages to being the last one, but one of the advantages is a lot of the smart things have already been said. So I'm unlucky in that sense. I wanted to talk a little bit about you filed FACTA, and we had the opportunity to read them. And then we came here to see your performance. We came here to see your positions come alive. And we came here to see your ability to respond to your friends' arguments. Because, you would be addressing some points that would have been dealt with in your factum and vice versa. So it's a real opportunity for us to get the picture in full color once and for all. And it's also an opportunity for you to respond to questions, and as Justice Sossin said, to take that as an opportunity to address things that are of concern to the bench. Because even if you think they're stupid or irrelevant or whatever, if you can respond to them and set them back on the right course, however bad they are, they're the ones who are going to be writing the decision, so you have to help guide them when the questions you think might not be quite so relevant, and set them back on the right track. And if there's a really important issue that is a problem for you, this is your opportunity to convince. And it's an opportunity for you to bring it alive. And I think it's really important to understand the difference between your written material, which sometimes can be longer, more complete, et cetera, in terms of your own position, and then the requirement to be nimble, to respond quickly, to be really good on your feet. It's just a different skill set. So I do think that I was hoping that I could come with a whole bunch of constructive criticism, but I actually don't have a lot, because you were very, very good, very polished. You responded very well to questions. You were very composed, very poised. You seemed very relaxed. I'm sure you were shaking underneath the gowns, but you seemed very relaxed. So I think that it's tribute to you, but it's also a tribute to the amount of time that I'm sure you've been practicing, because the more you practice, the more you throw the ideas around backwards, forwards, and upside down, the more comfortable you are with the cut and thrust. And when you know it, and you know you can start at the beginning, the middle, or the end, there is a comfort, and you will just feel more ready to give your oral argument. And of course you won't have time when you're in practice. You'll probably have 250 files, so, well, you know what? Sometimes you have more time and sometimes you don't. But it's a good thing to know, and it's also a good thing to say, okay, what's really critical about my point? What is going to be determinative? Because I'm here, and if you don't remember anything else, you got to say, why am I here? What do I want? And how does this court have the ability to give me what I want? And it's really important just to go back to the big overarching themes, to make sure you keep those things very clear in your mind. And I do, again, I think you did that very, very well. So I wanted to say what an honor and pleasure it was, and I think I speak on behalf of all three of us to say we feel very lucky to be here, to see you. It's always wonderful to see young people starting off. I think it's terrific. And lastly, before we finish, I think this is also an opportunity. If there was anything that you thought, well, I was thinking about doing this, but I decided not to. What do you think? Do you think I should have done this? This is an opportunity for you to bring those things to us, if you wish.
I was going to ask, what are your thoughts or suggestions in terms of prioritizing between different arguments? Because I think that I was basically just explaining arguments that I think are more complicated or less likely to be successful, and I actually did explain, I think, the more solid ones in my factum. Perhaps because, like, it's a moot, but I don't know in practice how do you prefer counsel hearing the court to prioritize between those two points?
I mean, that's a good point. I mean, I think I would certainly always focus on your strong arguments, because there's always a possibility that whoever it is you're before hasn't read your factum, or but people are human, and or they may not have read it in the way that you would like them to read it. So I think it's really important for you to focus on your strong points, but you also have to be able to deal with the issues that your friends have raised, and be able, because they're going to point out the point faible in your argument, and you have to be able to respond to that.
Yeah, no, absolutely. And in fact, what often happens in this kind of case, it wouldn't have made much sense in a Grand Moot context, is to say, as you're getting short for time, we're going to rely on our factum for the other arguments we haven't been able to spend time with. And often what you will get is counsel scratching and amending as it goes along what they had intended to say to, as Justice Thorburn said, deal with your winning argument if you think you have one, neutralize the strongest argument you think you heard from the other side, either in your turn if you're the respondent, or reply would often follow the respondent back to the appellant, and then rely on the factum. It's all there, and you don't have to feel like you need to rush through any of it, because all of it forms part of the submissions. The story you're telling, together with that more detailed review of the case law, walking through all the tests and structures.
In terms of the strengths and weaknesses of arguments, though, look for the pen. Because when the pen's put down, it means you've either lost them or you've got a struggle on your hands. So I think generally speaking.
The pen is a very 2011 idea, so what you're looking for is when
well,
you hear the
if
clacking.
you don't hear the clicking, okay.
You don't hear the clacking. But no, it's a great
okay, I'm
question.
old, I got it.
No, nothing to add. I think your strength, go with your strong arguments, and often what happens is that after you've kind of covered the argument you want to make, you weave in the response to a defense argument that you think really needs to be, or respondent argument that really needs to be answered. So there's no perfect formula, I don't think, but I think a good starting point is to kind of do that, my strong point, and then the opposite points that you anticipate will come. Get those, just as succinct as you can in your mind as to how you will deal with them, and that way, you'll get through most of what it is that you wanted to say, and then, the default will be to the factum if you run out of time.
The other thing is that you're only as good as your reputation, and so I think it behooves all of us, when we've had the opportunity to read the other side's arguments. Sometimes there are things that you say, well, actually, now that I've read their factum, that really wasn't a good argument. And sometimes you can add to your credibility by saying, I concede this point. Having seen this, I see that there's that Supreme Court of Canada case out there, but so I'm conceding that point, and recast your argument to focus once you've had the opportunity to look at the other sides.
That's great.
Anything else? No? All right. Well, it was absolutely a pleasure. I hope that you'll stick around for a few minutes. We're certainly here if you're more comfortable speaking to us one-on-one than you are in a group of 500 of your nearest and dearest. So please feel free to do that, and we're very delighted again to be here. Thank you.
Thank you all for joining us for this year's Grand Moot. We hope you all enjoyed tonight's event as much as we and our incredible Mooters enjoyed preparing for it. At this time, we would like to more formally recognize some members of the law school community who made significant contributions to this year's Grand Moot. So first, thank you to our faculty advisors, Associate Dean Essert, Professors Dawood, Hadfield, Lee, Milne, Schaefer, and Sue, and SJD candidate Matthew Marinette. Your guidance was instrumental in crafting a challenging problem, in refining the Mooters' arguments, and preparing them for tonight's panel. Thank you for taking the time to help make tonight a success. We'd also like to thank each of the Mooters for working so hard over the last few months to prepare for tonight. The amount of work that goes on behind the scenes is truly staggering, and all of that work is done with the purpose of making the Grand Moot as entertaining and as impressive of a showcase of the oral advocacy that U of T has to offer. So, round of applause for the Mooters.
This event, of course, wouldn't be the success that it was without the informed and thought-provoking questions from our panel. So a heartfelt thank you to Justice Thorburn, Justice Sossin, and Justice Maxwell for taking the time out of your busy schedules to be here tonight, and in particular to Justice Sossin for stepping in on such late notice. Thank you to all three of you. And please accept these gifts that Charles will helpfully distribute as a small token of our appreciation. Finally, thank you once more to our generous sponsor, McCarthy Tetro. McCarthy's continued support for this event is what allows it to happen year after year, and we're very grateful that they've chosen to dedicate their time and resources to the Grand Moot once again this year. And we'd like to invite Mike Rosenberg from McCarthy Tetro to say just a few words before we conclude for the night, and see you all at the reception. Thank you.
Well, thanks very much. It's wonderful to be back at the Faculty of Law. I vividly remember learning legal process in the predecessor to this moot courtroom from Professor Sossin, as he then was. He asked tough questions back then. It's nice to see that hasn't changed at all. Let me start by congratulating our Mooters this evening. That was an exceptionally fine performance of advocacy. And let me congratulate as well our Chief Justices for pulling together such a terrific problem. As always, very topical and ripped from the headlines. Let me thank our panel of justices this evening for such insightful questions and for adding that air of realism to the exercise. Advocacy is the lifeblood of what we do at McCarthy Tetro. And it is a real privilege to be associated with this wonderful event. I'm told I'm supposed to say we have some small tokens of our appreciation for the Mooters, so hopefully there's something nice in that bag. And let me just conclude by saying it's wonderful to see that the future of advocacy is in such good hands. Now I know I am what's standing between you and a reception, so I'm going to pass the microphone off and simply say congratulations again. Thank you very much.